They want to hear from the mayor. If y'all ain't learned that yet. The mayor, not the trustees that don't do nothing, that only run their mouth. Y'all don't do no work, no work. Y'all forget I am the leader.
Hide the money, y'all. There's poor people around. With your broke ass.
Every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections. You were first elected in 2021?
No, 2013 was my first election for trustee. I was a trustee. I sat where they are.
Right.
That's why I know the law.
Council.
Yes.
Elected mayor 2021.
Yes.
Terms 4 years?
Yes.
Okay. Plans of running for re-election?
I'm running for both my seats. And I'm going to win them.
So, and when is the election for Thornton Township?
2025.
So those elections at the same time?
They are.
Bullshit. A bullshit. A bullshit.
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long.
I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Yes. Well, I ain't take off the screen. I always do that. We will shut down. I'm trying to slow down on using profanity. But I want to say blessings and good afternoon to everyone. Welcome to Uncensored Enlightenment Talk. And you're here with your host, GRACELEVI. Now, I know we've been putting out a lot of information, but we're still playing catch up as well. This broadcast is going to highlight what happened at Thornton Township Electoral Board hearing. A lot of the clips that we captured today is going to be brought to you by Burgundy Blue. She went down there and got some good pictures, sound, and everything. So what we're doing today is clarifying who was knocked out, and we're going to look at it differently. You know what we do here. We're going to see who possibly may have to appeal. Okay. Now y'all already know it was already broadcast that Nate Field was allegedly knocked off. So we're going to verify that today. I'm looking at the picture, trying to put him on the screen. You know, that's my boy. No matter what, you know, as a young man, I support him. I support young people. We're going to talk about that. We're going to see how he represents himself, you know. So, you know, the last time I was like, oh, snap. I was like, no, hold your paper, Nate. Hold your paper, Nate. He was ready. So we're going to get into that. We may fast forward through some, but I don't want to miss not too much. So let's get to an update brought to us by NBC Chicago 22 hours ago. Some Thornton Township services halt after Tiffany Hilliard government shutdown. So let's talk about this first, because that is actually very important. And I kind of brushed over it the last broadcast because I'm like, no, she is not about to do this right by the holiday season, you know, cause people stress, and she really did it. Now, I just want to highlight, guys, I have to make you guys remember, do y'all kind of notice every time around election time, it's some type of government shutdown, they need more money, the budget needs to increase, okay? Now, and then every time that come, they, you know, do what they got to do to increase the national debt. This is pretty similar, right? I told y'all I'm not set tripping. Tiffany is trying to pull a Trump. So here she go with Miss Arrogant Self calling for a government shutdown, and she literally locked the doors. And, you know, like I said, I would understand some services, but then when you talk about transportation services, after school program, these programs that has been set up for years, over months, there should be adequate funding already there. They shouldn't have to sign off every month. So I really believe that this is unnecessary and this is wicked. Look at her, Miss Arrogant. Let's play this.
There is
turmoil in Thornton Township as some government services are shut down. Supervisor Tiffany Henyard's spokespeople tell NBC5 it's because of liability issues amid a lapse in an insurance policy.
We were in Thornton Township today, and that main building was locked. No one was answering the main phone lines, and some services that are offered there are for electric and heating for low-income homes. We spoke to Henyard's spokespeople today and trustees who are calling it a ploy.
What's going on? What do we do? What do we have to do?
Darlene Lewis was one of many Thornton Township residents who tried to get services at the main township building Wednesday, only to find it locked.
I'm going to be in the dark. My apartment is electric. I can't cook.
She risks losing electric services. Supervisor Henyard warned of a government shutdown the night before.
So was there a government shutdown, and that is why the building is closed?
Well, we were advised by the attorneys to close the building. The building shouldn't be open. The risk is great.
According to Henyard's assistant Keith Price, the risk is that they didn't renew their insurance. He says it's because two trustees, Chris Gonzalez and Carmen Carlisle, have boycotted the past few weeks of meetings.
They played Russian roulette with the insurance.
But trustee Gonzalez tells NBC5 they've never voted on insurance in the past and says Henyard could have just signed off on it. But now...
Do you hear that? That's why I just started stressing out. Let's finish listening.
Now, the insurance company chose to not renew the township.
I'm thinking it's just a ploy. So we can't have a meeting, at the township building.
Gonzalez said they are open to conducting necessary township business like paying bills, setting a tax levy, and discussing new insurance, but have boycotted recent meetings, saying Henyard is trying to use them to appoint her choosing of a new trustee to fill a vacancy. They want to stall that appointment, which could be a tie-breaking vote for future business, citing scrutiny of Henyard's past spending.
If she gets somebody seated in that seat where she has another vote, we're going right back to all that.
Instead, they want voters to elect who they want as trustee instead.
For right now, it appears only that main building is closed. It's unclear how long that will last. Trustee Gonzalez said bus services were still running and other township buildings are still open. The trustees plan to have a special meeting on Friday to take care of other essential business.
Hold up. So you telling me you could still have some services? Hold on. You could have some services, but you just chose to shut down the building? Yeah, that sounds like a Tiffany ploy. But you see how God is? We do got another update for you. You see how God is? She's such a witch. Got an update 3 hours ago. This is from WGN News. Judge ruled against Tiffany Power Graph. So let's listen to this. Let's see if this is the official ruling against Bird. Let's see what they got going on here, because we already know when it came to Dalton and Ronnie Bird, she was pushing so hard and the judge was so lax, and his reinforcement was so lax that she was still trying to push Ronnie Bird through, even corresponding with the Illinois State Police Licensing Board to try to get them up to date, and it didn't work. And they told them that he had to hand in all his stuff. So let's see what this is related to. I hope it's related to that, because you see how she do? She punched and then she get knocked right on the butt. I'm say God gonna get her. Let's listen.
All right, we've got some breaking news from South Suburban Dalton, where a judge has sided with opponents of Mayor Tiffany Henyard in an ongoing power struggle. Henyard has tried to work around trustees by appointing her own village manager, attorney, and police chief. The trustees sued. Now a judge has entered an order that clearly states Henyard's picks for those positions are out. No comment yet from Tiffany Henyard. She faces a re-election battle this spring for mayor of Dalton. Henyard is also suing after Democrats voted against slating her for supervisor of Thornton Township.
We already know about that. So did we get a win? And they showed Thornton, but that lawsuit had to do with Dalton, right? Because she was trying to appoint them there. So God be the glory is official with a judge's order. But yeah, she got punched in the face again. Still trying to execute power she don't have. And I can't even understand why she can't humble herself right now. You see what I'm saying? Get to the end, and she haven't been indicted, tone herself down, but she continued to be contentious. So let's listen to this. This is Allies of Thornton Township Supervisor Tiffany Henyard gets some challenges kicked off the ballot. This is brought to you by ABC 7 Chicago yesterday. We're playing catch up, y'all. But we want to see what happened in this meeting and see who said what. I got my notes from last time, so I know who did what, but we're going to reflect back. I had to look for those notes. I got them. Let's go.
Attorney Fields' name will not appear on Allies of Thornton Township Supervisor Tiffany Henyard were successful in getting some of her challengers kicked off the April 1st general election ballot.
Based on those things alone, this document should be overruled.
Resident Michael Smith was behind many of today's objections. After a short hearing, the Electoral Board voted to remove Nate Fields Jr.'s name from the ballot. He was running for supervisor.
I don't think this is fair. I think
What's going on with the service?
making a big mistake right now.
Fields Jr. is vowing to appeal the decision, which was based on the board's belief that he missed key procedural steps in the filing process.
One particular
procedure.
What was it? Statement of candidacy wasn't binded properly to the rest of the petition packet.
The meeting began this morning and took place in the township's headquarters in South Suburban South Holland. 2 other supervisor candidates were kicked off the ballot because of not having enough nominating signatures and other issues.
The total number of valid signatures.
This all comes as Henyard is working to get herself on the ballot after losing in a rare Democratic caucus vote a few weeks ago to represent the party. State Senator Napoleon Harris.
Let's stop right there because we'll be talking about that. They always get back to that caucus thing. We're going to keep our eyes on what is the response of Napoleon Harris and the trustees. But I always tell you guys the importance of administrative processes. Administrative process highlights the paperwork you file, the type of paperwork you file, the timely manner of the filing, who was notified, was it notarized? These are part of administrative processes, and just little things like that could get a murderer off trial. So there are laws and bylaws that govern this process, submitting of the paperwork and things like that. So we're going to deep dive into that into a later date because I'm hearing what they're saying. They're saying something basically is a procedure issue. And there's something about binding the paperwork together, which sounds very technical. And in my opinion, just listening, it doesn't sound like it's going to have weight. But let's listen because the board may have cited some laws and some rules that we can look at in a later date to see if they interpret it properly. That's what I like to do. I like to research, look at judges' opinions, see how they interpret things. When I took I took the entry exam to get into a law program, it was ridiculous. I did pass and I was accepted, but I could not go to law school because of my kids will be going to school the next 2 years. Also, I didn't want to get my license because I learned as a licensed nurse, you have a lot of restrictions and a lot of things over you and things that you have to abide by that you don't. So after that, I was like, I'm over it. But I learned a lot. And when how can I say, the interpretation of it is much different than what you may think. I literally had to forget everything that I knew from nursing. Just what I knew as a citizen and what I thought, and interpret different ways of a case being judged by a judge. And this was part of the entry test. So I want you guys to know that it's a little bit more than just the administrative process. So this is part of what we'll show you here, kind of like a little bit of interpretation. And know that I'm not a lawyer. I just know how to research. So even if my interpretation may not be correct, there are other interpretations that we can look at and show you, because those interpretations you can use in cases. Does that make sense? But in here, y'all not on an election thing. Y'all not on got nothing to do with this. But that's what we're going to do here, because we do have some audience that have, y'all deep divers. I look at my statistics. My statistics say y'all like to watch documentaries. And I'm like, perfect. That's why I like to talk. Okay, so these are the 3 candidates for Thornton Township Supervisor knocked off. Let's just get the names, because they only talked about Nate Fields. They highlighted him, maybe because they knew that he was something to reckon with. I had to give a young man some kudos. They like Nate Fields. They only talked about him. Like, what's going on with the rest of the people? So let me just get to this little short article brought to you by AOL. Look at her. I told you she had my boots on. Look at her. All right, let me move forward. 3 candidates for the Thornton Township Supervisor in 2015 were removed from the April ballot Tuesday after the Township Electoral Board upheld objections to the filing. Independent candidate Stafford Owens, and now we have who he is. Let me see something. I'm going to tell y'all. Okay, let me finish to read because I already made some predictions. I think I knew Stafford Owens was going to be getting out and Sydney Moore. I did. And we're going to talk about it. Independent candidates Stafford Owens, Nate Fells, and Sidney Moore were all disqualified due to issues with their required petition or other filings. A challenge to Harvey Mayor Chris Clark, who was running for the supervisor position under the Reform Thornton Township Party, was dropped. Now, y'all, do I got to get in? See, I'm about to get distracted. Do I got to get into Chris Clark? We're going to get into him. So he's still running? Huh. You see my face, y'all? Y'all better not even play. Talking about split the vote. Y'all better not even touch that, allegedly. Okay, and I ain't connected to nobody, but I already see the writing on the wall with that. Okay, but we'll talk about that. Challenges to the supervisor candidate were made before the caucus, before the Democratic Party and the Republican Party were held December the 9th. Despite protests from Supervisor Henyard, who sought to run for full term, Senate Napoleon Harris won a Democratic nominee. Henyard has filed a lawsuit. They're going to keep on talking about that. Okay. Henyard ally Michael Smith, Keith Price, who is a food assistant program manager. They're going to highlight that. They're like, that's your only job. So you know he ain't an alderman no more. He ex-alderman. That's like food assistant pantry manager. That's who she had there. And Henyard Township Administration brought a successful challenge against Phil. You see they keep talking about him. Failing to bind his statement of candidacy with his nomination petition as required by law. Henyard attended the hearing but declined to be interviewed. Fell said his removal from the ballot was a mistake of the electoral board, which ruled against him 2-1, and said he will appeal the decision in Cook County Circuit Court. So he is appealing. Okay. It's just another obstacle I have to overcome. Fell said, adding Price and Smith are doing their best to knock out any competitor instead of thinking about who the residents want. Phil said he is frustrated with the process and allowed a filing error to disqualify him from election, and that voters should be able to choose their candidate for supervisors rather than be limited by the board. The election board consists of the trustee Gonzalez, right? Gonzalez. I just pausing because this is, you see, I always got to pause, right? Everybody got 10 jobs. Jesus. He on both election boards? Wasn't he at the one in Dalton too? Am I tripping? Wasn't Gonzalez there in House in Tiffany? Tell me I'm tripping. From the Dalton one. Now, Chris, I can't be mad if they want to take 1 or 2 of your jobs away. This better be voluntary. I don't like it. Yeah, look, how he gonna be on the board though? You see what I'm saying? Ain't he running? Ain't he running for trustee? Right? What ticket he on? He a Democrat? Y'all get in the comments and tell me. We asking some questions here. I got stuck on this. Just on the first name, Darlene. Woo, she got 30 jobs. We just saw her on the school board over there helping Delgado get a job. Oh my goodness, man. If the FBI don't bust this up, y'all better be watching GRACELEVI. What is going on around here? And okay, let me keep moving because I got stuck right here. I'm just asking some questions. I just feel like things would be weird. Okay, so let me reread this. The election board consists of trustee Chris Gonzalez as a chair, trustee Darlene Gray Everett, and clerk Loretta Wells. And Gonzalez provided a sole no vote. Ooh. The board voted unanimously to disqualify Owens. And now I think Owens had the most mistakes. We're going to look. Who did not attend the hearing. Oh, he gave up. And Moore, who was found to have switched parties too recently for Democrats to independent. So that verified that Tiffany cannot go independent. You see what I'm saying? So knocked her out the box. You think she's gonna try to go? Hold up, I just got sidetracked. Do you think she really gonna try to overturn the caucus and then go like fully loaded? My God, I'm over here just imagining stuff in my head. Let's get through this article, okay? The board voted unanimously to disqualify those two, which was Owens and Moore, who was found to switch over into independent, as he said. Board attorney Tiffany Nelson, George Squeet, reported Owens did not have the required number of resident signature to be on the ballot. The action, pending court action, leaves Harris, Nolan, Clark as supervisor. So Harris, I was like, who is Harris? So it's Harris. I got to write this down because we're going to figure out who these people. Nolan and Clark for supervisor candidate. And we're going to put Nate Fells because he's going to win his appeal. He going to win his appeal. All right, I got a heart for Nate Fells. I'm praying for the young man. I'm telling you, you need to get rid of all these old people. They got too many intricate ties. The next generation is actually our generation, and there's not many of them that's interested in this. So you need to get the ones that are to start pulling the other ones so y'all can have somebody who's going to actually take these seats when these people croak. Unless they're going to keep on doing rituals trying to prolong their life. But let me shut up, okay? Gonzalez, I like you, but you tripping. Okay, Gonzalez said his votes were informed by Nelson recommendation based on the prior decision in similar cases. Okay. He answered my question when I said, you tripping. He like, well, it was based on a decision in similar cases. Gonzalez be knowing how to play his field. Like, he like, all right, I did some shady shit. But look, this is why. Okay. All right, Gonzalez, I got my eye on you. Okay. They're all different. Even though they may at heart be the same type of decision, Gonzalez said, there are different circumstances. So you have to take each one separately and kind of take it from there. He said he wanted to dismiss the objection brought against Phil because it appeared to arise from a simple misunderstanding of the rules. Gonzalez is running. He said he wanted to dismiss it, but he didn't. See, we got to look at that law. We got to see how that law is written about binding the documents. This is a simple interpretation thing. So if he appeal it, the judge is going to have to make a decision. But Nate has to bring the case law and the laws that kind of circumvent the circumstances. Okay, I see what y'all over here doing. Gonzalez is running for re-election for trustee as part of the slate led by Harris for supervisor. After this, I'm about to listen to y'all comments. When I pause, that means I got something on my mind. I want to say something, and then I probably won't say nothing. He acknowledged that his own campaign and relationship with various candidates would be perceived as a conflict of interest. Oh my God, I didn't even read this. That is exactly what was on my head. That's why I paused. You see how you bring it out? Well, the judge gonna have to interpret that now. You giving Nate Fields grounds because you even said it right here. It's perceived as a conflict of interest, allegedly, possibly, and that he support institutions a more independent process to decide the electoral objection. So he let the judge make the decision. You don't want to get any kind of personal thing involved in this decision, Gonzalez said. You just kind of keep it straightforward as you could, just like you were on a jury or something. Challenges the candidate's seat spot into a township board are up Tuesday. So, okay. Now, at least he know it looks like a conflict of interest because you're literally under the slate of the person that's supposed to be going against all these candidates. Why are you on a board? Why didn't they just let some of these people not be on a board? And I don't know, petition for other people to fill in? that kid that was qualified. I don't like it. I don't like it. Okay. So let's move forward. I'm not going to get into what does this say? Keep price, so I'm not going to get into they highlight that's why they keep highlighting Nate Fells, because he going to be back on that damn ballot. That's right. I'm making a prediction. Okay. You know what I'll do. If he don't, y'all can get on me. Just like I made a prediction about Tiffany suing. Okay. And I said she may win. Y'all get on me about that too. Okay. But look, this is Nate Fells out there doing it again. This was the second time he had to be back out there. All right. He put in that work. And that's why I think he's very ambitious in that if he can represent himself to at least get 2 of those things knocked down and submit the paperwork properly to keep the proceedings going, then that says a lot to me, because some adults can't even do that. You know that. Some of them can't even. So let's get into this. Just watch a little bit of the proceeding. We're going to kind of go through it a little fast, but I want to hear if they say any type of reference to laws when they're making their decision, like how they moved. I know the lady prior who was in the middle, I don't know her name. She seemed pretty, I'm trying to use the right word. I say honorable in the way that she talked and demonstrated herself in her position. So I will hope it's the same thing today. All right. So shout out to Burgundy Blue. This video is going to be in the description. I know she was one of the camera people there. Also, she has a section in there where Tiffany did that shady stuff. Okay. Because Tiffany got mad at the wrong people. Because at a documentary, her little slow self had ADHD and I forgot. She was like, it was one of you. And it was Lansing. And everybody like, it wasn't me. And CBS 5 like, I'm just playing. Let's play. Let's go.
Mr. Fields, you did not.
Okay.
All right. So at this time, there were no other cases that we're double checking, but I don't believe there was any other cases with signature examinations. The rest of the cases involved legal issues. And Mr. Quigley, I do understand that you also have an objection against Mr. Owens. When we call your case, it'll be up to you whether you want to proceed with the objection or withdraw. That's up to you. Obviously, you saw what just happened in these other 2 cases. That's completely up to you, but I don't believe.
Look, she gave Quigley a chance to back on up. She's like, I saw what you did in Dalton. You want to back up because you may not even be ready to handle these proceedings, allegedly. Let's see.
You have a signature objection. Would that be correct? Okay. And just for the record, that is DeMarcus Quigley. As you speak with DE, capital MARKUS CRIGG. That's for the benefit of the court reporter, everybody. All right, so we're going to call the rest of the cases.
Okay, so DeMarcus, he went against Owens. That was the 4th consent. I'm looking at my paper. Let me see what else he did. And that was the objection to his financial statement and his nomination paperwork wasn't handed in. That was him against Owens. Let me see who else DeMarcus did. He like, I can't represent that. They gonna get him for me. All right, that's what DeMarcus did. He done conceded again. He was just a ploy. Let's keep moving.
Because there's obviously more cases that we got to get to afterwards. For the next case we are going to call is case number 25-202, which is Keith Price and Michael Smith versus Nathaniel.
Nate said, I'm about to roll up in here like a pimp by myself. Per se.
Good morning. I would ask the parties both state and spell your name for the record. Let me ask the court reporter, do you need Mr. Price and Mr. Smith to do it again? No. Okay. So Mr. Fields, if you could state and spell your name for the record.
Nate Fields, NateFields.
Okay. And you are the candidate, correct?
Yes.
And for the objectors?
Michael Smith.
Okay, thank you very much.
I didn't get to the comments. Hold on, y'all. Y'all want me to get to the comments? I'm sorry. I just kept going. I got so excited because I wanted to see. All right, Jerry, let's put you on. I'm going to let y'all talk. You can see the anger in Keith Price's face. He's all ready to explode. Let me stop talking about him. Hey, Sher, how are you? Jerry or about to have a stroke? Who you talking about? Jerry? Who Jerry? Who Jerry? Jerry Jones? He not there. Grace, she's a narcissist. She will never have remorse, respect, or ever be truly humble. She's not evil. Just live to for serotonin rush. Shut up, period. She's just like it. She a narcissist. I know exactly who you're talking about. That was very descriptive. All right, Jerry, Tiffany, Thornton Township crew are the usual suspects. And they don't care. They be right there next to her at the interviews, at the thing, and then be right here thinking like you don't look suspect. One piece of paper did not have two staple holes in it, the bond package. Therefore, that piece of paper was not filed correctly. And per case law, listening to hearing, Keith and Judge. Okay, so we're going to get that case law and we're going to review this, okay, because he's going to appeal. He told the people he's going to appeal. So we're going to do a part 2 where we look at the case law and see if any judge did interpretation of it, okay, and what other factors that he may be able to use. Don't only think that when you bring in case law that it just has to do with that particular subject, like the bonding of the paper. It can have something to do with the whole electoral process as far as what we just saw with Gonzalez, biased properly, possible. Let me stop. You know what I'm saying? So it's a few things that he could stand on and see what the judge would interpret, because also keeping in mind, you know, the person's the judge don't only just look at it for that particular case. You got to understand this is talking about the election. There's already been issues with people being forced with slate. There was not in this particular case, but so much that it was brought up a couple of years ago and contested. So they keep that in mind, that it's still an issue with knocking people off of being candidates. So if the judge is not biased and he open-minded like me, he will keep that in consideration, that if you rule against someone like Nate, you're making it easier for candidates who are single to be singled out. You give more case law to that. So those are some of the things. That's why judges' interpretation and when they make decisions, it's much more intricate than just the people. Does that make sense? Especially when it has to do with election. So we're going to dig into that because I'm not an election specialty, Lish, but I just, the structure of the way that people supposed to think and approach stuff, that's kind of like what I know. So that's kind of what I applied it to. But he definitely, we're going to look at the binding of the paper and what they say directly. Okay. Nate came alone and did perfect. Ooh, you saw it. You watching it with me again? Thank you. Nate has, I think, 10 days to appeal. Okay. When we do our part 2 this weekend, I'm going to be doing some research. Yep. And let's see, can we do a part 2 later on in the week to see what we find, what rules, election rules, and submission of paper, just like we did with the caucus. How about that? Okay. Price personal food box buffet. You know they're gonna always make us know that he missed the thicker than the snicker over the food. But you know what? We're shocked me, and I didn't hear it yet. I want to hear how Smith articulate himself, because people get on Smith about being alleged. You know what I'm saying? A map. Y'all know what that means. If y'all don't know, put in a comment. I'll tell you what a map is. I made that word up. But if he carried this thing through, he ain't as dumb. Because I was thinking that Keith Price was going to do it with his deep diving tricknology law interpreting ass. I'll be like, yo, he did it. Jerry, yeah, DeMarcus and Keith and Michael up front and center with Tiffany sitting behind them smirking. Kamal was in the back room where the TV cameras were set. Hold up, where set sent to Burgundy Blue. Walk right past him, only to be told she ain't belong by Keith Price. I do apologize. I read it like that. Yeah, we're gonna get into that. And I think what I heard is that Burgundy handled it pretty good. She's like, I'm a YouTube. I gotta go. Whatever. I'm about to argue with this stupid lady. Kept it moving. Went right back to where she was. I'm telling you some things you don't even have to make it a big deal. Like whatever. Darlene and Jason, and that Caucasian lady lawyer were there to vote. White, Caucasian. You know what I'm saying? I don't trust that lawyer. She would never answer questions that went against Tiffany. She would just say, quiet, what? And play deaf. Oh, we got to listen to this. Let me get to this. Okay, shout out. We got Paul in the group, in the chat. Keith Price and Michael Smith may be looking to Chris Clark for future jobs. Their plan B after Tiffany. Hold on one second. Who challenged Chris? I'm trying to see because I have wrote down everybody who was challenged. When did they challenge him? Because you know he wasn't there. He was the first one to be challenged. Yes. Thank you. That was the first paper. Thank you, Mr. Roberts. I appreciate your insight. Yes, that was the first contest of the 9 that was given. And he did go against Clark. All right, let's get this playing because y'all educate me. I'm getting all excited because I ain't watched. I was like, ooh, let's watch it, y'all. I'm gonna play it a little fast to see if we can get through this. I appreciate you guys being here. And I appreciate you, Mr. Roberts,
On this case,
your interpretation of things as well. We do like experts, and we have, if Isaac, one of our followers, is here, one of the family members, I know he popped in the chat. He seems very incisive. He has a good insight, so I like when he adds to the conversation if he's here.
if the board recalls, we set a briefing schedule that required all briefs to be filed by December 9th at 5 p.m., replies to be filed by December 11th at 5 p.m. I'm sorry, responses to be filed by December 11th at 5 p.m. and replies to be filed by December 12th with the hearing set today.
Oh, there you go.
In order to expedite these matters, it would be my suggestion to the board, and this would be for all cases, that the board institute a 10-minute limit on oral argument for both parties and the movement of the motion. So whoever filed the motion would be able to split their time up if they wanted to. If they wanted to have 7 minutes on their presentation and 3 minutes on reply or rebuttal, they could certainly do that. Would that be something that the board would like to do in order to expedite these matters? And if the parties need more time, they can always ask the board for more time, and that would be up to the board. But just for the sake of expediting these cases, it is a very long call. So would the board like to do that? Okay, so then I would ask for a motion to institute a 10-minute time limit for oral argument for all cases to be heard.
Okay, don't go longer than that.
This one we can just do all in favor, any opposed? Okay, motion carries. So with that, I'm just going to give a little procedural history as I see, and obviously the parties are welcome to dispute the procedural history in their oral argument. So the electoral board rules do require that motions do be sent to me, and my understanding with Mr. Field, you did not send it to me, you actually filed it with the clerk. So technically that's not compliant with the rules. Obviously the other side may have some issues with that, so they're going to make their statements, I'm sure, but just wanted to, I guess, put that out there. And
oh my God, they got me mad, but it's true. It's called notification. The people, everybody's supposed to be notified who they said throughout the proceedings. So I hope Mr. Nate Fells know everybody who he's supposed to notify. Okay, anybody who's on that letter, those letters they send to you, they name, send them all a notification, and the clerk. Oh my gosh, I'm sorry.
You did file something, in fact, and then that was sent over to the objectors once we realized the filing, and it was sent over, I think, maybe a day or two later. So the objectors, if memory serves me correct, and please correct me if I am wrong, I believe the objectors did not file a written response in this.
No, we're going to stand on our objection.
Okay, I just wanted to make sure that the record was clear. Okay, so then at this time, I think it'd be appropriate to begin the oral argument. And we'll take care of the timer. Okay. And my colleague Hannah will take care of the timer for us. And if you could, when we're getting close to like the 2-minute warning, 2-minute, 1 minute, just to make sure that the parties realize where they're at. And before we begin oral argument, does the board have any questions on the procedure? Okay. All right. Thank you. Mr. Fields, you can go ahead and start presenting your case.
Okay, so I did file with the clerk's office that response, and the clerk's assistant did notify me and say that she would email that filing to you. I know that the code report said that I was supposed to file it, and letting me know that she would send it to you. To me, in good faith, don't like it any timing to you. But as far as the objections, Keith Price and Michael Smith filed objections to myself on November 25th. The objections alleged the failure to file a statement of economic interest and failure to identify the office sought. Now, the second claim was voting the ballot of an established party during the previous election primary ballot. Number 3, petitions not bound properly. 4, the statement of candidacy of political party affiliation passed. Now, number 1, failure to file a statement of economic interest. Under Section 10.5 of the Illinois Election Code, candidates are required to submit receipts for the appropriate office, verifying that their statement of economic interest was filed. I complied with this requirement by filing the statement of economic interest with the Cook County Clerk before the statutory deadline. Now, submitting the stamped receipt from the Cook County Clerk as well to the Thornton Township Clerk's office along with my nomination papers. I also included that receipt as my proof. While the receipt does not explicitly state that the office of this omission does not invalidate my candidacy, the receipt's sole purpose is to confirm that the statement of economic interest was filed with the appropriate office, which it is. The statement of economic interest itself includes all required information, including the office of, as mandated by Section 4A-104 of the Illinois Governmental Ethics Act. Thus, there is no ambiguity about my candidacy or the office for which I am running. Now, the omission of the office sought on the receipt is a minor clerical defect that does not impact the validity of the receipt or my compliance with the election code. To further demonstrate my transparency and accountability, I also filed an additional notarized statement of economic interest with the Thornton Township Clerk's office. While not legally required, this statement of economic interest includes all necessary information, including the office sought, reinforcing my good faith effort to comply with all legal and ethical requirements. Number 2, the non-participation in party primaries. The objector alleges the issues regarding my candidacy based on Section 7-43F of the Illinois Election Code, which applies only to individuals who vote in party primary and then attempt to run as an independent candidate. I did not vote in the primary election of any established party. Therefore, this section does not apply to me, and there is no legal basis for disqualifying my candidacy on these grounds. Number 3, independent candidate status and statement of candidacy. The objector claims that my statement of candidacy does not explicitly state that I'm running as an independent candidate. While this language was omitted from the subsequent statement of candidacy due to clerical oversight, my intent has always been clear. On October 21st, I filed nomination papers, including a statement of candidacy, explicitly identifying myself as an independent candidate. These papers remain on file with the election authority and have not been withdrawn. I've included that proof. Section 7-10 of the Election Code requires candidates state their party affiliation if applicable, or if running independent, include a statement that they are not affiliated with any political party. While the subsequent filing was omitted, this explicit language, Illinois election law recognizes the principle of substantial compliance. The totality of my filings demonstrate my clear intent to run as an independent candidate, eliminate any potential confusion amongst voters or elected officials. The omission of the subsequent statement of candidacy is a minor technical defect that does not affect the sufficiency of my nomination papers or the integrity of the electoral process. Now, to resolve any procedural concerns, I respectfully request the opportunity to amend the statement of candidacy to explicitly state that I'm running as an independent candidate in compliance with Section 7-10. Now, as far as the proper binding of petition, the objectors alleged issues regarding the binding of my petition. However,
okay, let me stop right here. I'm just gonna tell you this. This right here, Nate came out gunning. Okay, the way he represented himself, the way he articulated his words, made him solidify his position. He said that, hey, I may not have had it on the paper, but my intent was known, publicized, and by way of this document and other filings, you see that I have filed independent. So not only did he represent it nicely, then he came with a resolution. He said, well, we can have a solution to this by me amending it. That's what made them have respect for him. That's why they really like highlighting Nate. They know he about to come back with some stuff. Whoa, you see me, I got excited over here. Like, let me find out Nate need to go to law school. It sounded like that. Ooh, let's finish. That's a young man, y'all. Talk better than some residents. Okay, let's listen. I'm so proud of him.
Were properly bound at the time of filing. The petitions were neatly fastened together in book form, secured at one edge and numbered consecutively. This compliance is evident in the scanned documents provided by the election authority. The petitions meet all requirements under Illinois Election Code, and there is no valid basis for disqualification on these grounds. Now, the objections raised by Keith Price and Michael Smith failed to demonstrate any material or substantial defect in my nomination papers that would disqualify my candidacy under Illinois law. All requirements of the election code have been met, and any minor technical errors do not impact the validity of my filings or the clarity of my candidacy as an independent candidate. For these reasons, I respectfully request that the electoral board strike the objections in their entirety, 2, allow my candidacy to proceed, and 3, grant such other and further relief as the electoral board deems.
Okay, thank you.
Good job. I want to hit a law bind documents.
All right, that's 4 more minutes left on rebuttal. Should you so choose to use it after the objectors state their case? All right, objectors.
First thing we're going to attack is the motion to strike and dismiss. According to the rules of the electoral board, and I'm pointing out rule number 9, filing and service of documents. Unless otherwise specified by these rules or permitted by the order of the electoral board, all documents filed by a party in connection with the proceedings on objection shall be filed with the electoral board's attorney in person during the proceeding of the electoral board. In person at the electoral board's attorney's office, which is located at Delgado Law Group, LLC, 1441 South Harlem Avenue, Berwyn, Illinois, 60402, by fast mail, 708-222-7001, or by email. All documents filed by a party in connections with the proceedings shall be served by the filing party upon every other party to the proceedings in a manner reasonably calculated to provide actual and prompt notice to that party. Each document filed with the electoral board's attorney in connection with the proceedings shall also include the filing party's written certificate setting forth the time, date, and manner in which the document was served on all other parties. If the party has considered to service by fast mail or email, service may be made by that party via fast mail or email. 2 things I want to note. When you talk about a motion to strike and dismiss, the law states there are 2 prominent things that must be in that. Number 1 is a proof of service. We have no proof of service in this document. Number 2 is the notice of filing. Based on those things alone, this document should be overruled, should not be accepted by this electoral board. It does not show a proof of service nor a notice of filing. And that's in accordance to the Illinois State Board of Elections code. And it was not emailed to us as a party. All right.
All right. So listen. So this basically is a procedure error of notification. Now, that is up to them to decide to move forward because all parties do get notifications from the court. And I think that's what Fells thought that was sufficient enough. But even with me, because I think back to real estate, everyone who is connected to that deed, I have to put them on notice that I'm moving forward for foreclosure, even into the next of kin. Anyone who has any type of entitlement to that case. And if I don't do that in certain instances, depending on how strict the judge is, especially in Maryland, oh my God, they will basically make you have to refile because it'll be a failure of notice. Now they won't like say that you can't, that you lost the case. Do you see what I'm saying? So maybe this is why they have some leniency. And I'm just kind of interpreting it loosely because I'm going to get into the election laws. I'm going to get into that. But I'm kind of just thinking from me when I deal with court cases, they all pretty much the same. It's about notification, about to the right parties, about having the right paperwork filed in a timely manner, as well as citing the right law and all that stuff we're talking about. So that's what made me think about it. So they gave him, if they dropped that, they gave him some leeway. I'm going to be honest. If they dropped that, they gave him leeway, but they shouldn't have been harsh on him anyway, because that happens a lot. And then people could just get to refile. But because there's no time to refile, that's probably why they didn't, the board, or how we can say you called the white lady who was Tiffany lawyer, didn't go ham. Let's listen.
That's on that. To talk about the objection in itself. As the candidate alleges in his motion to strike, he puts forth the evidence that he did not file a statement of candidacy, a statement of economic interest, which lists the office which he is seeking, which is Township Supervisor. That is in his packet labeled as Exhibit A. This is a fatal flaw in accordance with the election code.
He did.
And it states, inclusion of the office sought is made mandatory by Section 10-5 of the Election Code, which provides that all nomination papers are invalid if a candidate fails to file a statement in relation to his candidacy. Candidate's statement of economic interest which fails to list the government unit invalidated the nomination papers. That's Fortis versus Washington, 87 EB ALD 56, Chicago Electoral Board 1987, White versus Thomas, 87 EB ALD 126, Chicago Electoral Board 1987.
Let me start right there. That may not hold because the statement of economic interest, even though it do have to be filed after the caucus in relation to the Democratic caucus, I don't think that applies to independent candidates. The economic interest paper may have to do with their economic interest related to their party and people they connected to. I'm not totally sure, but I definitely know the mandate for that is after the caucus, and there's a certain time frame, and that was the Democratic caucus and the Republican caucus. So that's probably why Nate was like, I don't have to actually file that, but I did, being nice. So what is Smith still talking about? Let's listen.
In regards to the other statement of economic interest, the candidate submitted two statement of economic interest, neither of which are valid. One does not have an official stamp from the Cook County Clerk's office in its notarization. The other statement of economic interest does not provide the office sought, which is required by 10-5 of the Election Code. All right. Our next alleged by the candidate and his...
He said the office sought. I was like, what? Sought? I think he's a sought after, or the one that he's attending. I don't... He said sought. I had to really like, what? Okay. Talking about way we talk. Jesus.
Statement.
Salt.
Is candidate statement of candidacy wasn't binded to the rest of his petition packet. This notice was reviewed when we reviewed the original petition packet in the clerk's office. Statement of candidacy, statement of political party affiliation absent. Section 7-10 of the Election Code provides, among other things, that a statement of candidacy shall state that the candidate is a qualified primary voter of the party to which the petition relates, referred to herein as the party affiliation statement. Candidate failed to properly bind petition packet should or make the statement of candidacy stand alone. And in doing so, it violates said section of the Election Code by not listing its party affiliation statement or none thereof.
Okay, where does it say that has to be bonded to the petition? I want to hear that law that says that the statement of candidacy has to be bonded to all those petition papers.
So I'm asking for this electoral board 2 things. Number 1, that the candidate's name not appear on the ballot based on the fact of rule of law, that the candidate failed to file a stamped copy of a statement of economic interest with the office. And then the other thing is that the candidate failed to list the office in which he's seeking on his statement of candidacy. And I'm asking also that the electoral board overrule the motion to strike and dismiss for not properly being filed, as well as not having a proof of service and a notice of file.
Is that all for the objectors?
Yes.
Okay, thank you. All right, at this time, Mr. Fields, you have an opportunity to respond.
Okay, the objectors claim that I didn't file the statement of economic interest correctly. And then they add on, I didn't include the office saw. But the fatal flaw is not filing my statement of economic interest. That's filed. You said it wasn't stamped. It's stamped by Markham Courthouse. And also filed with my petitions. Every other document implies, even the ones I filed prior to, said that I'm running as an independent candidate. And everyone knows that I'm running for Thornton Township Supervisor. There's no mistake, no mistakes made. Everything I did was in good standing. I went and got petition signatures twice. I got them all by myself.
Okay, good.
I mean, I'm doing this thing the right way, and we still got people that want to try to stop, you know, but it's expected. Another thing was that I did not bind my petition. You guys said you saw my petitions in the office. What office did you read my petition?
Mr. Fields, it's time to argue toward the arguments should be directed towards us.
Oh, I'm so sorry.
It's okay.
I'm so
It's
sorry.
okay.
Okay, the objectors claim that I did not file my petitions correctly. They bound it correctly. They were bounded. They were numbered consecutively. And I did follow the guidelines within the Illinois election code. I think that the objectors might have saw my petitions after they were taken apart and scanned, and then they assumed that all the documents were binding together. But they claim they went through them on their own with their hands. My thing is that I saw petition sheets through the scanned document. I'm trying to see how they saw my petition sheets. Was it taken apart and did they come down to office and see it taken apart and scanned in physical copies? But that is my argument, that how they saw it. I've heard them in scan binding. It might have got taken apart in the scanning process. I know they have to be taken apart in the scanning process unless they're on scanned in individuals. Now, as far as filing the response, I'm sorry.
Just about 20 seconds.
Okay, so yeah, I did file with the county clerk. I mean, with the authority elections for the clerk's office. That she did notify me that she would send that filing to, and that's.
All right, so basically Nate has a question of allegedly how these people saw the paperwork. Now, I would hope they did it legally, Nate, because they can't Freedom of Information request this information as public and candidates. But you can Freedom of Information request the clerk of any Freedom of Information request made in relation to your paperwork connected to these two individuals directly, or anyone. You could do that and see what the clerk give you. That's a Freedom of Information Act on a Freedom of Information Act, because you get to see who had made requests for certain documents. The reason why I know that works It's because y'all gonna be like, she weird. I be watching the missing in park, like missing 411, and the gentleman who do missing 411, all these national park missing stories, he will freedom of information request these stories, and after a while they started blocking him. So he had other individuals freedom of information requests, but then he started to make freedom of information requests to see who was asking for the same paperwork. And he was noticing that all of his requests wasn't going through, and some people requests was going through, because that's part of, you can request that. So it just popped in my head, because I was like, oh, that's weird. And he said how he ended up getting the paperwork he needed to find out about the missing people, because this is just real life. He contacted one of the people who made the Freedom of Information Act request, because the national parks was giving him a hard time. Does that make sense? I know I be thinking too much, but I watch a lot. God be making me watch this stuff so I could think. So do a freedom of information request and see who petitioned your paperwork, and if they actually did it. And if they did not do that and they got to see it, maybe that's something you need to look into. But yeah, I was thinking, let's move forward.
Okay. All right. So at this time, both parties have presented their arguments. The first order of business would be
Don't you say we have a rebuttal as well?
no, they're the movement. The movement gets the last word. That's why I said if you guys have anything more. If the board wants to entertain additional statements from the board, does the board have any objection? No. Okay, go ahead.
All right, so thank you all over the board. I want to just direct your attention to the actual objections on number 1.
Wait, you're not supposed to do that. I thought you said it was nothing after Nate speaking. What's going on here? What's going on here?
It says failure to identify office salt and failure to properly stamp, to add a proper stamp on statement of economic interest. So for the candidate to throw out that we just added this at the last second, that's not true. It was on the original objection.
Oh, wait, I don't know. Let's just verify that, because that's what I was saying. Maybe I didn't write fast enough, but I don't remember all of these objections. That's why I was kind of like, where the hell, excuse my language, where did the binding come from? Originally, writing it down, one was the failure for the petition to identify was they a Democrat or independent. I wrote that down. The second one was a statement of economic interest. They said that he failed to do it or he did it late. And that was there too. That was there too. Let me see. Everything else, the lady who named was Sheila Ashley, the other one who kind of petitioned the same thing, objective, no statement of economic interest, no indication of the office, and the filing time of the petition. I'm just trying to see, did they pick this up from somewhere else? Because it did seem to get amended, because Nate Fells only addressed, well, he did address the binding of the petition. So they had to amend something, because I'm like, yo, I'm looking at my notes and I'm like, Dag, do I not take verbal dictation fast like I used to do in nursing? How did I miss 2 more? So they did something. They did something weird.
Furthermore, when I personally reviewed the petitions in the clerk's office, after looking through all the petitions, I noticed that the one particular
view the petition in the clerk office
wasn't binding properly.
Is that legal?
To the rest of the petition packet. I asked the assistants in the clerk office, is this how it was turned in? She said yes. You can clearly see that one document that I do refer to.
Nate, you better make sure that he fills some paper out to look at your petition in the clerk's office.
In the challenge will not have any holes in the top as if it was bound with the rest of them. So, we stand on the rule of law from the election code, and you can also look at the actual petitions for yourselves.
All right. Does that conclude oral argument? Okay, thank you. So the first order of business before the board would be to determine whether it wants to accept the filing from Mr. Fields that did not technically comply with Rule 9 of the Electoral Board's rules. Now, if the board chooses not to accept the filing, that just means that document does not go into the record. Obviously, the parties still argued their case, so you would still make a decision on the merits. So it's really up to the board whether the board wants to accept late filings or filings that, and not late filings, this filing was actually timely, it's just not technically in accordance with the manner in which the filing was supposed to occur, which was to be filed with me with copies to the opposing parties. And the only way that the opposing parties actually were served was through me sending it over to them saying that this was filed. So how does the board want to proceed on that?
I'm glad I know what happened because I would have been anticipating like, ooh.
Yeah, the rules were adopted at the last board meeting. And I would ask, just for the benefit of the court reporter, if we could speak into the microphone so that we can have an accurate record. I did get it in a timely manner, and then it was sent over to the objectors, possibly a day later, I think, just because truthfully, I'm getting about 200 emails a day. So I think it was sent to them either the day of or maybe a day later. They obviously chose not to file any sort of response. Either way, the parties have argued their case here today, so it really doesn't impact much, if you will, except it would either be included in the record or their arguments would be included in the record based upon the oral arguments that were presented here today. So it's kind of just a procedural thing. If the board wants to accept the late filing, it can. If the board determines, no, we're not going to accept the late filing, it can certainly do that too. And the parties obviously have argued their case. You know, the case would, regardless of a motion to dismiss, the case would still proceed on the merits. And we just had an argument on the merits of the case. So again, it's up to the board. I'm sorry. Oh, no, you're allowed to discuss. Absolutely. So yeah, I mean, I guess.
What you got going?
What questions do you have? Or what sort of? Oh, yeah, absolutely. In open session, all deliberations.
I have to stop and say shout out to Burgundy Blue again. Please like and subscribe to her page. She has got clear audio, clear sound, and she was there. I think she did 2 things in one day. She been on the go, and I told you they ain't easy for us older ladies to handle all of this. I'll be having to take a nap. I ain't taking a nap today just so I could go live today. Okay. So shout out to Burgundy Blue, and I'm going to put her link at the bottom. Okay.
Have to occur in open session. So it would be appropriate though to have a motion and a second one way or the other, and then have a discussion after that. So a motion to either approve the late filing or a motion to, not late filing. So a motion to approve the filing in manner of filing by Mr. Fields, or a motion to deny the filing by Mr. Fields.
Basically, these people got to think if they're going to take the paper or not. His filing wasn't served to everybody. The board has a right to not accept it. Regardless, Nate there gave his oral arguments, which cited law. So that puts that on the record when they make the record. So it's like, okay, she like, either way, you know, he still put his oral arguments in, and it can be basically reviewed if it's appealed for the most part. So next time, Nate, everybody, even just send one to yourself and your mama. Everybody should have one. Put the whole world on notice. I wish that's something that y'all could do in this election process, but that's something we could do in real estate. If we can't find all the parties, we can put, it's called a world notice, and we could put a notice in the newspaper and say anyone who has to do with this, da da da. Now, I don't think the election do that, but we'll look into it.
And then the second, then we need to have discussion on that.
Just make the decision. Good job, Gonzalez.
Okay, so we have a motion by Chair Gonzalez to accept the filing. Well, we got to speak into the microphone so that the court reporter can hear everything. All deliberations have to be in open session. So the board has discretion to deviate from its own rules. So if the board wants to say, okay, we'll accept the filing, the manner of filing, then that's the board's decision. If the board doesn't want to accept that manner of filing and say, no, you filed it incorrectly, we're not going to allow this document to be a part of the record, that's fine too. That's the board's decision. Either way, the parties did argue the case on the merits, so you will still issue a separate decision, if you will, related to the merits that were presented. And, you know, all the documents that were presented by the parties are, I believe, already in the record for the most part. So, yeah, it's really up to the board if you want to accept the late filing or not.
They scared
Or not late filing, the manner of filing. So, okay, so we've got a motion to accept the manner of filing by Chair Gonzalez, a second by Member Loretta Wells. I will now call the roll for that. Is there any further discussion before I call the roll? Okay, I will call the roll.
I'm a little confused because,
well, the election laws don't actually dictate the manner
of the paperwork.
Well, the election law does not actually dictate the manner of filing or service of documents as it relates to these types of motions. That's actually dictated by the rules. And the board, under its own rules, can deviate from those rules should the board choose to. But that is a completely discretionary decision of the board. And so, as of right now, we've got a motion and a second. So, is there anything else that you wanted to state there, Member Gray Everett? Okay, all right, then I will go ahead and call the roll. Chair Gonzalez, Member Wells, yes. Member Gray Everett. Okay, motion carries. Mr. Fields, you're.
Gray Everett said no. She probably scared of Tiffany. Like, wait, just tell me what it mean real quick. Gray Everett said yes, but Gonzalez said yes. What am I supposed to do? Now, what the hell did she chose? Whatever it is, it didn't pass. It passed.
Filing will be accepted into the record. Now we're going to move
Can I
on.
put something? Can you also make on a notice of record that you're ignoring the fact that
Oh my God, he pulling the Love. Do y'all know who Love is? Love is the prosecutor in the YSL trial that wouldn't shut the hell up when the judge made the decision. Every time the judge made a decision, she kept, I said no. This is what he's doing right now. Hold him in contempt, please.
he did not have a notice of service as well as a proof of service? Can we also put that on the record? I'd like for that to go on the record.
That's in the record. It's already in the record. And this is just related to the manner of filing in general. And that deals with the manner of filing. So
Slow down, Tito. Damn, you about to have a heart attack. You didn't even let them finish.
that will be duly noted in the record.
Let's catch a dog. That's him, y'all. Let me put him on the screen.
You know what, you can do whatever. I first of all,
This guy. This Keith Price now.
Because of possible relationship, that's a disservice to anybody else that is or may not.
your comments are noted for the record. All right, so next we will move on to the actual deliberation.
She said your comment is noted for the record. Moving forward.
For the objections that were stated. The first objection is that there's a failure to specify the office on the statement of economic interest. The objectors have stated and cited multiple cases from the Chicago Board of Elections, have stated that this is a fatal flaw in their view. However, I do note that there has been a lot of litigation on this case or on this issue. And most recently, there was actually a case last cycle at the Chicago Cook County Officers Electoral Board. And I'll have to get that citation, but there was a case last cycle at the Cook County Officers Electoral Board where the Officers Electoral Board determined that a failure to state the office is actually not a fatal flaw. Also, so there's a couple cases, a couple things I want to read into the record. In the Jones versus Municipal Officers Electoral Board case, the appellate court held that the candidate's statement of economic interest was not in relation to his candidacy and that it did not adequately specify the office sought. Jones versus Municipal Officers Electoral Board held that Third Ward was not a sufficiently complete name of the office sought, and that the legislature intended to make mandatory rather than directory the inclusion of the office sought. That case was decided in 1983.
Damn.
About 50.
That was petty. Someone challenged that the word third ward wasn't the correct way. Oh my God, this should get petty. Let's listen. This is the case law she's comparing it to.
15 years later, the court in the Illinois Appellate Court in the Requena case, REQUENA versus Cook County Officers Electoral Board, that court also dealt with this same issue. In the Requena case, the court determined that the candidate should not be removed from the ballot for failure to sufficiently specify the office she was seeking on her statement of economic interest. Additionally, in Cardona, CARDONA versus Board of Election Commissioners of the City of Chicago, that was a 2004 case. The appellate court held that the election code does not require that a candidate specify the office sought. And again, that is a 2004 case. There is also a case that I personally worked on, Guerrero versus Franklin Park Municipal Officers Electoral Board. And in that case, the candidates did not specify their office on their statement of economic interest, and the appellate court found that that was not a basis for removal. So the appellate court has more recently held that a failure to specify the office is actually not a basis for removal. Given the case law that has been presented, it would be my recommendation, and the board, of course, will deliberate over this, but it would be my recommendation based on that the objection be open on that basis. So the board now can deliberate on this matter. Does the board have any questions? To overrule the objection related to the failure to sufficiently state the office on the statement of economic interest.
Yes, petty. Moving forward.
Does the board have any questions on the law? Okay, so at this time, the board should, I'm sorry? So the law generally states that a candidate is supposed to file the statement of economic interest in relation to their candidacy. However, the case law that has been interpreting that, there has been a bit of a split. Like I said, the Jones case back in 1983 said that in fact was a fatal flaw. And I know the candidates, cited a bunch of City of Chicago cases. Some of them do say that, some of them say something a little bit different, but the overall, or I'm sorry, they only cited, I'm looking at a different one. They only cited Fortis v. Washington and White v. Thomas. Those are both 1987 cases. Since 1987, in 1998, as well as in 2004, the Illinois Appellate Courts have determined that the failure to state the office sufficiently on the statement of economic interest is actually not a fatal flaw, and the candidate should not be removed from the ballot for that reason. So that's the case law that governs this issue.
She came prepared. She came prepared because, people don't remember all this case law. She did her homework. I'm just
based on the case law, it would be my recommendation as the electoral board attorney that the objections related to the failure to identify the office sought be overruled. Right, but that's not the objection that we're dealing with right now. That would be the next one. Correct. And for the record, if the board wants to see, I do have the original nomination papers here. The office sought, just for demonstrative, is blank. So that's the question. Is that line required by law? And if it is required by law, is a failure to include that a fatal flaw? The courts have come out in the Jones and the Burgundy case and the Guerrero case Well, if I mean, the Jones, I'm sorry, the courts have come out in both in Jones, I'm sorry, in Requena and in Cardona, as well as in the Guerrero cases, the courts have stated that the remedy for mistakes on your statement of economic interest is actually not ballot removal. It is penalties of perjury. So the courts have stated that because there is this other penalty that's provided, the courts can't read into the law that the penalty of ballot removal would be the proper penalty. So that's where the courts stand on this. So at this time, I would need a motion to either overrule or sustain the objectors, the objection as it relates to the failure to identify the office side. Okay, I have a motion to overrule as it relates to the SCI issue, as it relates to the office side. Do I have a second on that?
Everett don't know what she doing. She don't know what she doing.
Okay, we have a second by member Loretta Wells. At this time, I will take a roll call on that motion, and this motion is specific to the failure to identify the office sought on the statement of economic interest. Chair Gonzalez. Yeah. Member Wells. Member Gray Everett.
Confused. She gotta go. This old lady gotta go. Get her out when it's her time. Hello. There she go. This one right here. She confused. She confused, and the lawyer trying not to have too many issues. She like, okay, do you understand this, Miss Everett? Take the mask off so you can hear, please. She confused. Oh, she gotta retire. Y'all see why we need some young blood in there? Please. Hurry up. Please.
Okay, position noted. Right, exactly, and that's exactly what the Illinois appellate courts have stated, is that the penalty for mistake is not ballot removal. The penalty for mistake is the penalty of perjury. Okay, thank you very much, Member Gray Everett, and members of the board. Okay, so the next one.
You understand what they said? They can't give him a penalty of pulling him off the nomination for that, which is going to be like equivalent to fraud. That's the same penalty for fraud. So they kind of like, we don't even have a penalty set up for that. Let's just not even touch that. And Everett just confused. Please pull her out. Whatever her time is, she got to go.
We have on the list of objections for this specific candidate is that the failure to submit a stamped receipt of the statement of economic interest. I do have a copy, or I do have the original nomination. Have a proper stamp on statement of economic interest. Okay, I'm gonna try this, guys.
They're not supposed to be
Okay,
talking.
so for the record, Mr. Fields did in fact file two.
He not supposed to be talking right now. They supposed to be making the evaluation. It's getting on my nerve a little bit, but we're gonna keep marching forward.
Statements of economic interest. It looks like one appears to be filed with the Cook County Clerk's Office, and that is this one that has the stamp on there. And then there was a second one that was filed. Either this one bears no Cook County stamp, but there was a second one that was filed with the Township Clerk's Office. But I do note for the record that this is actually the old form. And I can tell that just by the fact that it has $5,000 all over it. And the new form is, I believe it has 10,000. It's different questions, basically. It's different questions that were asked. However, the filing, the law requires that Mr. Fields and any other candidate for this office file a statement of economic interest receipt, file a statement of candidacy, and file the nomination petitions. Loyalty oath is allowed, not required. It does say it's required, but case laws come out and said that no, you actually can't require that. So those are generally 3 documents that need to be included in every set of nomination petition, or maybe not per se in the actual set that's presented, but they need to be filed within the filing period. So as it stands, Mr. Fields has in fact filed those documents. There is case law related to people filing additional documents that are not actually required by law. So that case law essentially identifies those additional documents as surplusage, as essentially what that is additional documents that really have 0 legal effect on the petitions. So it would be my opinion that this additional statement of economic interest that is not even the current statement of economic interest that's in use is mere surplusage and has no legal effect on the petition.
So if you don't understand what happened, he filed 2. So I don't know if he thought he had to file one at the township and Cook County, but the one he filed at Cook County was in a timely manner and had the seal. The other one that did not have the seal, that was the one they were trying to go after. They so petty.
And as such, I would recommend overruling that objection.
Good job, Laura. Let's see about the last one. I want to hit a low. Miss Avery gotta go. She's stressing me out like Henyard.
No, they're saying, and the documents bear this out, that he essentially filed 2 statements of economic interest. One with the county, which is where he filed the receipt with your office. And the second one was this additional document, which is not correct. Didn't have to file that with you at all. Didn't have to file this one, period, because it's actually not even the correct form. Yes, exactly. If this was the only one, then we would be having a very different conversation. But the fact that there is a valid statement of economic interest in the packet that was filed stamped by the Cook County Clerk's Office on November 12th, 2024, and was filed within the filing period, as far as we know, with the Clerk's Office, the local election authority, then the additional statement of economic interest
is surplus.
It's mere surplusage and just essentially extra documents. So it would have the same legal effect as filing 5 extra blank pieces of paper, really, or filing a candidate profile with your nomination petitions. There is no legal effect to it.
Study long, Miss.
So we do have a motion to overrule the objection as it relates to the filing of the additional statement of economic interest that was not stamped by the county clerk. Do we have a second, or do we have an opposite motion? Okay, so we have a motion and a second on that. Okay, we'll do the roll call now. Or Member Graber, do you have anything that you'd like to offer? Okay. Member Chair Gonzalez? Member Wells? Member Gray Everett? Okay, that one is overruled. Now, the next objection that we have is
I'm like, is she about to ask questions? Okay, I think this is the most important one with the bonding.
the failure to identify the office slots.
No.
I'm sorry.
What is the binding, right? You sleepy?
I appreciate right now the board is in deliberations. So please respect the process.
I understand. Dirty cat.
The next one is that the candidate is running as an independent.
Okay.
And didn't state his party on his nomination petitions. The state and the objection that the
Didn't they go over this already? I'm confused.
The objector's petition states, and I quote, section 7-43F clearly and unequivocally prohibits a person who voted the ballot of an established political party at a general primary election from filing a statement of candidacy as an independent candidate for an office to be filed at the general election immediately following the primary at which the person voted on the primary ballot. So what this is typically, referred to as, it's sort of an anti-party switching thing. So what it generally means is that you can't vote, say, Democratic in a primary, and then at the same general election following that primary, within the same election cycle, that you can't then either circulate for an independent candidate. So, or you can't circulate for a party, and you can't circulate for an independent candidate within the same election cycle.
Okay, it seemed like it's in the same election cycle, and Tiffany did all the above. All right, okay.
You can't vote for a party and then be an independent candidate within the same election cycle.
Okay.
Now, the question then becomes, what is an election cycle? An election cycle is the primary in general for that same election to ultimately elect those officers. So right now, we are looking at the municipal 2025 election cycle. We just got out of the presidential 2024 election cycle. So the primary in March that we just had, in March 2024, that was part of the November 2024 election cycle. The February 2025 election coming up is part of the April 1st election cycle. So you look at it in pieces. And it used to be many, many years ago that it wasn't looked at in such a piecemeal manner that if you voted, say, in the March primary as a Democratic candidate, then you could then circulate for the next year's April election as an independent. So the party switching actually, the prohibition used to go on for 2 years. They changed it and said, no, it's only within each specific election cycle.
Okay,
So what you need to look at is whether any evidence has been presented, and whether there's even an argument, even if evidence was presented, that the candidates voting for an established political party at a general primary election, whether that impacts his statement of candidacy that says he's an independent. Now, as I stated, when we talked about what an election cycle is, the primary for this election is the February primary, not the March primary. So it doesn't matter under the law whether Mr. Fields voted in March for a Democrat, a Republican, a Green Party, a Libertarian Party, or an independent. It has absolutely no bearing on what is happening with this election cycle, which deals with the February and April ballots coming up.
Okay.
Try to explain it as clear in manner as I could. It's kind of a complicated thing.
It was like the year before. That's what I was thinking, because I was trying to interpret it from the caucus rules, but it's in the same election cycle. Distributing papers, all of that. Tiffany did all of that. So I don't know. You think she's gonna still try to get on a Democratic ticket? That child, she would too. She like, I'm gonna get on it. I'm gonna be above all y'all again. Okay, moving forward. I'm not getting y'all mad.
as it relates to this specific type of division, yes, because there is no, the way that it often gets violated actually is that people circulate in, for the February election, they circulate for the primary as a political party.
Yep, Tiffany.
And
see,
so they circulate.
And she circulated for people as a Democrat. See, didn't I just say that? That's just like, that's how it get violated.
Please stop.
I gotta get comfortable.
Anyways, so they circulate at the general, or I'm sorry, they circulate for the primary election for a political party. Say they circulate as a Democrat or a Republican. And then they want to then run as a candidate or circulate for another person as an independent. So they can't do that. You can't party switch within the same election cycle. So I can't go out and circulate for a Democratic candidate for the February election and then myself decide that I'm going to be an independent candidate for the April, or circulate for my colleague who's running in April. So does that explain it?
Okay, who said that?
Okay. So as it relates to this specific objection, given the law, it would be my recommendation that the board overrule this objection because there's been no evidence that the candidate voted in the primary. The primary is not occurred. That's February 25th, 2025. So as presented, the objection, in my opinion, is not well founded in law and should be overruled.
All right, let's go.
Okay, we got a motion to overrule by member Chris Gonzalez, or by Chair Chris Gonzalez. Do we have a second?
Second.
Okay, I will call the roll. Chair Gonzalez, member Wells,
Yes.
member Greg Everett. Motion carries. That objection is over.
Good job.
Next, we move on the failure to bind the statement of candidacy to the nomination petitions.
Okay.
So when Mr. Fields was arguing, he was arguing more about the binding of the petitions as a whole. But what the objector's argument is not that the petitions themselves weren't bound, but is that the statement of candidacy itself was not bound within the petitions. Now, as a practitioner, I can tell you that we always put the statement of candidacy with the petitions because that's what we believe generally needs to be done. And usually we feel that that's the best way to make sure everything is all nice and tight and neat and everything's going where it needs to go. The law on this is a little tricky though.
Okay.
So the law does in fact require that the nomination papers be neatly fastened in book form by placing the sheets in a pile and fastening them together at one edge in a secure and suitable manner. The election code also states that nomination papers must include a statement of candidacy under section 10-5. The election code does not specifically state, however, that the statement of candidacy needs to be bound within the nomination petitions. So there has actually been a lot of litigation on this issue. The Nader case, this is Nader, N-A-D-E-R versus Illinois State Board of Elections, found that section 10-4 requires a petition when presented or failed shall not be withdrawn, altered, or added to. And that part of it has been found to be a limitation in some courts, or in some cases, to preventing the filing of the statement of candidacy as a separate document. However, because law is never 100% clear, that's why you guys always have to fight us. In 1984, the Chicago Board of Elections voided a candidacy when it determined that the candidate filed his sheets at 9 a.m. in order to preserve a ballot position in the lottery, and then filed a statement of candidacy and loyalty later at 10:34 a.m. Then the Valentine case, V-A-L-L-E-N-T-I-N-E versus Bardwell, B-E-R-D-W-L-L. That case is cited as 132, Atlanta 3rd, 1033. In that case, the candidates of the new political party were found to have substantially complied with the election code by filing their statement of candidacy 4 days after filing the signature sheets, but before the expiration of the filing period. It should also be noted that Valentine is a case that falls under Article 10, and why that's important is that
only 12% of women-owned firms.
Oh, don't you do that to me. I was in the middle of dictating. And you're gonna scare me like that. I'm sorry, y'all. I do apologize. That shit was loud.
Actually,
how you gonna do that? All right, Burgundy. I ain't mad you monetize. I know that's right. I was waiting for a commercial though. Shout out to Bird. That shit scared me. Scared the lights out of me. I'm over here trying to document. All right, I'm getting a smile on my face because it sounds like it's mixed case law on this. Let's finish listening, y'all. Hold on.
Just for the board's own identification. Article 7 deals with established political parties, and Article 10 deals with independent parties and new political parties.
Okay.
However, the first district appellate court allowed a candidate to remain on the ballot, but the candidate failed to file their statement of candidacy with their nomination papers and instead filed them 3 days later. And that's Courtney, COURTNEY versus Cook County Officers Electoral Board. Also citing Barnes, BARNES versus Benes, BENES. It's a Chicago Board of Elections case, 95 EB ALD 214. And Washington v. Means, that is case number 11 EB ALD 124. Those are also Chicago Board of Elections cases, all following for 10.
Okay. Now y'all know what we're gonna do next because we haven't did this before. But our next live, we're gonna go over case law. We're gonna show you where to pull up the case law. It's pretty easy, and we're gonna read it, y'all. It'll probably be a little long, but we're gonna compare and contrast because we're gonna try to figure out what the appeals judge is gonna try to say. Okay. Woo, I'm excited. Y'all excited? Nate Fells, you got fight. Fight like you're Tiffany. Fight to the death. Okay, I had to say that. Go Nate. Go Nate. He represented himself well, y'all, for a young man. He did a great job.
This question, despite all this litigation going on about this and all these cases about this, this question came up again 2019 in McCaskill versus Municipal Officers Electoral Board for the City of Harvey. In that case, the court opined that fortunately we can harmonize and give effect to each statute, i.e. the filing of multiple sets of petitions and the adding to prohibition. There are many ways a candidate might seek to add to the petitions in violation of section 10-4 besides filing an entirely new set of nomination papers. For example, the candidate might have omitted a required document from his filed nomination papers like a statement of candidacy and might try to add it later. Or the candidate might want to add more petition sheets to his filed nomination papers, fearing a lack of valid signatures. Section 10-4's language would still govern those situations, among others. We have not read that language, i.e. adding to, out of existence. So there appears to be a split amongst the courts, but the most recent word that we had is from the 2019 McCaskill versus Municipal Officers Electoral. And reading this, our review on the case law is, truthfully, I think that this is a call for the electoral board to make to determine whether they feel that the failure to include the statement of economic interest in a balanced manner with the nomination petitions, whether the electoral board determines that that is some sort of it impacts the integrity of the election process or the petitioning process, or whether it impugns some sort of fraudulent conduct or otherwise impacts the integrity of the election. So,
Okay, Gonzalez, I'm getting mad a little bit because you voted against him, and they said that she gave you. Oh shit. Oh hell. I'm thinking here, look like Nate gonna have a case, dog. Yes, because she's like, listen, if it doesn't affect the process or the integrity, or it's no fraud, and it's so mixture of court cases, she's trying to explain. Okay, Gonzalez, you see this? I'll put my fist up.
with this one, truthfully, I am torn, and I leave it to the board to make a decision as to what the board wants to say. Because the board can only go either way.
Wait, I'm about to be like Tiffany. Don't be mad at me. You're black and you're Spanish and you're turning your back on your people. I'm sorry, y'all. I just have to say it. What's wrong with you, Gonzalez? Let's finish watch this. I'm tripping, y'all. I just had to get this off my chest.
in this matter, the question really isn't whether this final say a certain time. More saying that it's generally accepted.
Correct. Correct. I mean, there hasn't been an allegation raised that it was filed separately, like a couple days later or anything like that. The allegation, as I read it, is that the statement of statement of candidacy rather was not found with the nomination petitions.
Thank you.
So that's what the law is. It's tricky. It is under some courts, and some cases it appears to be required, and some they dispute whether it's required. These cases range from, cases as recent as the Casco versus Municipal Officers Electoral Board. That's a 2019 case. That is a first district appellate court case. And that case appears to say to me that it is required to be filed with it, because otherwise it would be adding to petitions after the fact. Like I said earlier, there are other cases which do predate that 2019 case, but those are the 2000 cases, or the 2000 case, that's the Courtney versus Cook County Officers Electoral Board case, where the appellate court said, they can go ahead and file, but 3 days later, it was filed within the filing period. No harm, no foul.
Thank you.
So really, the courts are split on this, but the most recent word that we do have on.
Put your hand down, Thickums. I see your hand going up. Put your hand down. No objection to case law. You saw his hand go up?
That is from 2019, where the court in Casco basically said a failure to put the statement of economic interest and just put all the documents together, basically. Put everything together and bind it all together and file it all together, with the exception of the statement of economic interest, right? Because the statement of economic interest clearly under the statute can be filed separately. There was statutory language as to that fact. But with the statement of candidacy, the ultimate question is whether it needs to be included with the nomination petitions. The Courtney case is definitely on point. However, like I stated, when I say it's on point, it's very similar fact scenario with the exception of in the Courtney case, the statement of candidacy was filed 3 days later. However, the Casco case did give a clear directive as well to state that under section 10-4, you can't add to your petitions. And is this considered adding to petitions?
No.
So that's really
no.
Right. So that's really, what the board needs to sort of wrestle with.
The petition is the signatures. That's not adding to the petition. None of the arguments is talking about that. Shut up, Keith.
So the Illinois Election Code does not specifically specify that the petition, that the statement of candidacy needs to be bound with the petition, but that's been the overarching interpretation. Section 10-4 provides that the petition sheets be neatly fastened in book form. And then section 10-5 provides that the nomination papers must include a statement of candidacy. So the interpretation
is
for the last 20-something years of
Yep. I'm going to read that. We're going to read that together. But from what I'm hearing, even the interpretation of the law, she cited 2 different codes. One that specified what was the conditions for the petitions to be handed in, and the second code, what was the conditions for the like you choosing what party you on. That's what that was the issue. It's 2 separate codes. Now, if it said that these 2 supposed to be bound in together when they talked about the petition, then that's different. There's different rules that govern the petition versus this particular paperwork and the paperwork of economic interest. 3 different ones. So we got to look at the difference, because you can't just intertwine and mush them together. And that's what she kind of trying to tell y'all. I think this Caucasian lady and trying to warn them. Just letting Nate get by. But you're black. You're doing this to black people. I'm sorry, y'all. I'm trolling. Let's go.
The interpretation has always been you put the statement of candidacy with the nomination papers. However, like I stated, the Courtney court, as well as the Chicago Board of Elections in a few instances, and the Valentine court, have found that filing those separately can be okay. Now, us lawyers often use this one guide called the Illinois Continuing Legal Education Guidebook, and it's got this whole chapter on election law. I was reviewing that chapter last night, and in part of it, it does state that, well, in some jurisdictions, this is found to be okay. It's a very dangerous thing, and we highly recommend that candidates find their statement of candidacy for their petitions. So, again, I think this is,
Recommend.
the courts kind of are split on it, but the most recent word we have on it is from the 2019 McCaskill case.
That's not part of the procedures.
Well, in the McCaskill case, it said basically that you can't add to the petitions later. If it sort of solidified that principle and, talked about that principle. I don't believe it actually specifically addressed the statement of economic interest, but it was talking about just overall filings, documents. So again, I think that there's kind of a split in the courts as to what the law is, but according to the McCaskill case, which again is the most recent case, nothing can be added to it. They do state a specific example where they say a candidate might have omitted a required document from his filed nomination papers like a statement of candidacy and might try to add it later. So the McCaskill court was specifically talking about a situation.
Everett confused. Gonzalez on the slate.
In that same 2019 case, it says without any allegation of fraud or proof of the integrity of the process had been effective, they recommend objections. We'll remove the objection.
Well, that was
I'm going to say that's right.
So that, I mean, the board can certainly make a determination as to whether, they feel that the board, whether they feel that the failure to include that impacts the integrity of the process, or whether the board feels that strict compliance with section 10-5 and 10-4 is required.
Have you heard about the people who are investing in real estate?
They did good with the commercials. Sometimes they be killing us. They did good with these.
Well, not using elections. I'm sorry. Usually, I've read it correct. I mean, my interpretation is that you are supposed to find all the documents together.
Girl, you stupid. That's not what it say, probably. It's two separate codes. It better say that. It better bind them together, girl. Wells.
Okay, so do you make a motion to sustain the objection as it relates to the failure to bind the statement of candidacy with the petitions? Yes.
Okay,
so we have a motion to sustain the objection as it relates to the failure to bind the statement of candidacy with petitions. Do we have a second on that? Yeah. Okay, so we have a motion made by member Loretta Wells and a second made by member Darlene Gray Everett to sustain the objection as it relates to the failure to bind the statement of candidacy with the nomination petitions. I will now take a roll call. Chair Chris Gonzalez.
Yeah.
Member Loretta Wells.
Yes.
Member Darlene Gray Everett. Motion carries. The objection is sustained as to the failure to bind the statement of candidacy with the nomination petition.
Hold on, y'all.
With section 10-5 and 10-4 is required.
I want to hear this clear.
I'm sorry. Usually, I've read it correct. I mean, my interpretation is that you are supposed to find all the documents together.
I can't stand her. First and foremost, you're a clerk. That's not you're not supposed to interpret it. You're just supposed to file it. The lawyer explained to you interpretation. Ma'am. Wells. Once Wells said that, Tiffany walked up to the front, walked up to Keith, pat him on his back, like, don't worry, we got it in a bag. And then Keith got up, fixed his pants because he's about to run out behind her. But like, wait, it's not over. Okay, I'll be there in a second, ma'am. That's what just happened there. Whew. Stressed me out. Let's finish watch. Ooh, wow. That's why I said that. Y'all know who I'm talking about? That's why I said I don't trust it. Your interpretation? Did you ever take a law class? Did you ever take a law research class? You're the clerk. I already told you guys, clerk is not supposed to interpret law. I don't care. You on this board, you got a lawyer that interpret law. I'm mad at her. Ooh. Okay, y'all. I'm just about to cool down. I'm mad at her. I knew she was weird. I knew she was.
Okay.
Look at Dirty Cat.
Okay, so do you make a motion to sustain the objection as it relates to the failure to bind the statement of candidacy with the petitions? Yes. Okay, so we have a motion to sustain the objection as it relates to the failure to bind the statement of candidacy with petitions. Do we have a second on that? Yeah. Okay, so we have a motion made by member Loretta Wells and a second made by member Darlene Gray Everett to sustain the objection as it relates to the failure to bind the statement of candidacy with the nomination petitions. I will now take a roll call. Chair Chris Gonzalez.
Yeah.
Member Loretta Wells.
Yes.
Member Darlene Gray Everett. Motion carries. The objection is sustained as to.
She actually voted yes. She voted yes. He said no. They had two opposite votes. Wait.
The
No, it stressed me out that I got confused. I swear, it stressed me out.
By the statement of candidacy with the nomination petitions. Finally, we do have one last objection in this matter. This relates to a failure to list party affiliation on the statement of candidacy. In that objection, the objectors list section 710 of the election code. And I would just note that 710 is not applicable in these proceedings. It's actually, so that's an incorrect citation. And in addition to that, as an independent candidate, Mr. Fields is not technically required to list any sort of party affiliation. And there is plenty of case law saying that if somebody files, say, a nonpartisan nominating petition for an independent race, that's okay. So it would be my recommendation to overrule that objection.
She tried to tell him.
I make a motion to overrule. Okay, the motion to overrule made by member Wells. So we have a second? Okay, Chair Gonzalez?
Yes.
Member Wells?
Yes.
Member Gray? Okay, there being no other objections related to this, Mr. Fields, there will be a written decision and objectors. There will be a written decision drafted and we will come back here. Do you guys want to try and settle on a date now? That's let's you have to come back and actually substantive decision. Let's look at our calendar real quick. Does December 30th or December 30th, preferably December 30th work? December 30th is a Monday. We would be hoping to schedule them all on the same day. Sooner, not really, because we're gonna need time to write the written decisions. That is right after Christmas. I'm not gonna be in town the 26th or 27th. 30th, member Gray Everett? Do I need to be here? Okay. Okay. Okay, well, this will, so this will be just to issue the written decisions. So if you're not able to be here, member Gray Everett, and member Wells and member Gonzalez are able to be here, then that's fine, as long as we have a quorum. And this will be solely for the purpose of issuing the written decisions. So again, yeah, I would say 10 a.m.
Yes.
And in relation to the trustee cases that'll be coming up later, if those cases are fully adjudicated, this will, this date will be reserved mostly for written decisions. If there's anything substantive that needs to happen, at least on the supervisor cases, we will try and work with your schedule. Another great up. Okay, so this matter, I just need a quick vote from the board to continue this matter to December 30th at 10 a.m. for issuance of the written decision. And just for the record, the written decision is that Mr. Nick Fields' name will not appear on the ballot. If we let's remove the ballot as it relates to the one objection for the failure to bind the statement of candidacy with the nomination petitions, and all other objections were overruled, and the written decision will reflect that. A substitution, I'm sorry, I don't know what you mean.
Oh, thick ass. You know, I'm talking about Keith Price. You know, put on his glasses, talking about we done. Oh, you make me sick.
Sure. The decision has already been made. So this is just issuance of a written decision that reflects the matters that were discussed here today.
So the decision has been made, but I'm not going to appeal on the ballots as an independent candidate for electing right?
Yes, because the objection was sustained as it relates to the failure to bind the statement of candidacy with the nomination petitions. And that was sustained on a 2-to-1 vote.
Although the documents were filed at the same time, again,
Just go ahead, just appeal it. He filed them at the same time. The case laws that they put up, and we didn't read them yet, but they said that one was filed, the 1984 case, one petition was filed at 9 a.m. and then the what is it called? They said this is the candidacy. You choose who your candidacy paper. That one was filed at 10:34 a.m. and that was good. Then there was another one that was the same situation and that was good. Shit. Go ahead. I know you mad. You doing great, Nate. Especially had to deal with Catch a Dog Smith and thicker than a Snicker KP. Whew, you did a great job, sir.
the electoral board agreed that I'm not going to be on the ballot.
I said Spanish. Puerto Rican.
Even though I work this hard for signatures and for full township, our board can't come to a decision to determine the candidates. That simple mistake as far as cases and simple biases.
Yep, that's what it looked like. I think Nate is basically saying they don't have the authority to make a legal decision as the board, like, you know, but they do. But I think he's saying in the capacity of determining case law. But I think that's what he's talking about.
Well, you do have appeal rights, sir. And once you get the written decision, and the written decision will reflect that you have 5 days to file an appeal with the circuit court. And so at that time, once you receive the written decision, you are certainly more than welcome to file your appeal. We would put together the record and then you would make your case before the circuit court. You know, as you heard during deliberations, the state of the law was read to the board, and this is the determination that the board made. So the written decision will be issued on December 30th at 10 a.m. So if you would like to appear in person for that, you certainly can, and we will give you a copy of the written decision once it's signed by the board. If you are unable to appear, you just can let us know that we're waiving personal service as it relates to the statutory service for the decision, and we will email it to you.
Go down there on the 30th, get your paper, already have your appeals paper already ready, because you're going to attach that decision to your appeal paper that's already filled out, and we're going to be taking it up, okay? These people, and I thank you. I don't know what Gonzalez is, but I had to crack jokes because that's Tiffany thing. Oh my God, Nate did a great job. We're going to get to the most significant parts because obviously what you see is that the other candidates was knocked out the box and one petition was withdrawn of Mr. Clark. And that one, right? Chris Clark. Yeah, we're gonna have to do a deep dive on him. Let's finish listening, and then we're gonna get to the part where Tiffany kicked out the trustee. Kicked out the media. So we'll get to see that because Burgundy Blue got those clips. Shout out to Burgundy Blue because it was all like written about what Keith Price said, but she got it. It looked like she got him slamming the door, coming there, talking shit. His old coming, I'm the general. Well, let's finish play this, and then we're gonna hear what Nate has to say at the end, and we're gonna end this live. I want to say thank you for you guys being with Grace Levi, and I did get that message. I appreciate you. Thank you, because it was always used against me. I used to be the geek, but I still didn't give a damn. Like, did you know? Did you know? They be like, oh Lord, here she go again. Yes, sir. All right.
Mr. Price, Mr. Smith,
Yes, ma'am.
do you waive statutory service of the decision?
This email was fine.
Yeah, they so fast got up. The procedure wasn't even done. Yo, disrespectful asses.
Okay, so they will accept email service of the decision.
Look at
Okay,
it.
thank you. Great, we have to move on to the next case.
I can't stand them. Let's move forward. Let's get to the when they shot it up media.
Why are you not investing in tax?
This is my favorite commercial, y'all. This is my competitor right here. Okay, I invest in tax liens and tax deeds, so I be gunning at this dude. So I got sidetracked. So I was with y'all. I be starting my live like, why aren't you investing in tax liens? And I'll be like, because you don't know what you're doing. Don't follow this guy, his 5-step plan in 30 minutes and end up losing your money. So yeah, this is my competition. You want to show him on my stream? Tell him I'm gunning for him out here in Atlanta. I'm coming. I'm right behind you, sir. See, I'm telling you, that's my competition. That's my competition right there. Let's finish watch this. That was an infomercial, y'all. At the end, you'll see primetime home buyers. Me and him competition right there.
Your name? I'm Burgundy Blue. Burgundy Blue. Nice to meet you.
If y'all don't know what y'all watching, because I got sidetracked, this is when that Henyard said all the media go in a certain little room, and that they was gonna get a little sneak peek of what she had to say. And all of a sudden, she caught post-traumatic stress and a little bipolar and didn't know who she was mad at and kicked the wrong people out. Lansing, allegedly. Okay. Because Lansing didn't do anything, saying that they're bloggers.
Oh no, that would imply responsibility, accountability. None of that. No.
Let's see what's going on here.
All right, I'm gonna do my best. Critical, we miss you. Critical smoke, come back. All right.
See? Good job, Burgundy. I told y'all it's hard. She like critical come back. It's hard work. It is. This shit hard. I'll be trying to do a commercial, record myself. I'll be like, Lord, this is not easy.
No,
Yeah. No, don't apologize.
Shout out to Burgundy.
You break it, you buy it, right?
Thank you. That's
hey guys, hope you do the best I can.
I want to talk to the news.
Okay.
Okay. All right. So then, okay. Sorry.
All right. No, thank you. Yeah.
sorry about that.
You could have just directed me. I'm the only blogger in here.
Oh, really?
I think
I thought everybody was bloggers. She said everybody else. She said all others.
Oh, she said all of
Yeah.
Go back in.
That's right.
Okay. He said I could go back in. Okay, he let me back in.
They'll let you back in?
Yeah.
All right. Okay. No problem. Good. You should have picked that one.
Okay, they let me back in, guys. Let's see.
Okay. What they got going on?
Yeah. Oh, yeah.
Okay. I guess they wanted to figure out who was going to say they was a blogger. And when Burgundy Blue walked up, the only one, he probably like, oh, shit, that's a resident. Probably went to Tiffany and Tiffany said, no, everybody. And who else in there? Let's see what happens. I'm fast forwarding.
What is that about? Is that a control thing or is that it's a control?
Get to him coming
out there. Definitely go back out there.
Okay, let's see.
All right. She's only talking to the actual news. She's not talking to, she doesn't want it.
Okay.
We are actual news.
Well,
Yeah, what does that mean?
I don't know.
I'm from the Lansing
Chicago
Journal.
trips.
Yeah. She does consistently reporting online just because we're online.
Same thing. That's not my call. So I had an interview with them.
TV.
You're about to have Lansing file some paperwork against you because they're actually the news. But Trump, you know, when they be doing those the presidential speeches and then they don't acknowledge some news broadcasters, I don't know, can they sue? But this one, you put out the news, so you got a problem. You cannot acknowledge someone who's actual news, but I don't think you can put them out. Well, maybe you think it's because she was holding a press conference selectively. Nah, I don't think so. I don't think so.
She gonna talk about
TV. I'm not sure. I'm sure they'll air it.
Well, why are we playing these games? I don't understand. We're coming in.
I don't know. Did you ask the electoral board while they're playing games?
Well, let's talk about it.
No, exactly. That's the thing. We just want to talk
Let's
about.
talk about it.
How does that have to do with anything, Keith? What is that? The electoral board is playing games. What does that have to do with this?
You asked them why they were changing the rules they adopted?
News, not.
What the hell does that have to do with? Oh, I'm sorry, y'all. Oh, I said I wasn't gonna curse. I almost made it the whole broadcast. You see how mad he looked? This is how he made me mad. Oh, I just grabbed his face, y'all.
You can see here. Yeah, that's news. That's definitely
They're
news.
more than 100 years old, so.
No, I don't know. I mean, it's definitely like the TV thing. It's fine. I don't know why you can't. She likes being on TV.
Right.
It's just like the thing. All right, we're headed out. So the Tribune, I don't know why the Tribune can't be in there. That's weird. Yeah.
All right, y'all saw what happened just there. Oh, that just got me mad. And then, Keith, I'll be still trying to give you a little pass when you said, "Oh, it wasn't me. That's what I told her." You know what I'm saying? I'm like, okay, he got some common sense in my head, and then you gonna go talking about, well, the electoral boy, you tell them. What the does that have to do with the cup of tea in France? Okay. Ooh, he's such a gaslighter. He pissed me off. We are 2 hours into this broadcast. I want to say thank you guys for being with me. Y'all actually been here through the whole thing. We're just going to show what Nate Fells have to say. Our part 2 to this is where we're going to go into the election board laws that they were talking about. It says Article 10 was the one that applied to Nate Fells. In Section 5 and 4, we're going to highlight that. And then we're going to get to some of this case law that they highlighted. They highlighted at least 1, 2, 3, 4, 5, 6, 7 cases. So we're going to see if we can find up to 10 and see, balance out which ones would you agree with? Because... and then could y'all clarify to me, because you know I'll be mad at Wells, but it sounded like she didn't go against Nate Fells. That's what it sounded like, right? Sound like it was Gonzalez that went against Nate Fells, right? So just clarify, because the article said it was Gonzalez, and it looked like Wells was like, okay, y'all just because I got a little confused. Everybody was just talking too much at the end. Y'all good. We did good. We 2 hours into this seminar. This is how I get a little blurry at the end of my nursing seminar. By the end, I'll be like, y'all recording? Lashley's clunking out. All right, let's get to the end, because the most important part is Nate Fells to me. All the other candidates, I pretty much knew that they were going to be knocked out the box, and we just going to say who that was knocked out the box. Not Chris Clark. He's still going to be in there. LeCline is still going to be there. And Harris. These are the ones that's going for supervisor. And allegedly Nate Fells in my eyes. Sanders, that's the gentleman with the dreads and the forehead. I think I got his picture, y'all. That's how I remember him. He had made his announcement, but he had so many things contested against him. It was just terrible. I was like, that man ain't about to make it. I don't think I got a picture of his forehead. But they had a lot of objections to Sanders, more no disrespect to him. The multiple filings, I don't know. It was in the right time frame. 160 pages was circulated that they were contesting the signatures. And something else about late filing. So he was knocked out. Owens was definitely knocked out. And Owens was another one. He did a lot of mistakes. Owens, they got him on signatures, possibly not numbered, and I think that's what they got him. He wasn't even, when they cross-referenced the signatures. You remember I told you guys do that to Henyard, but nobody did it. Double signatures, they were saying, non-voters. Y'all should have just did that to Henyard too. Statement of economic interest wasn't done by Owens. Remember I told you, I said, oh, he out of here. On the top of my paper it says knock out the box, right? I said Sanders, I said if his son and he get his lawyer there, possibly. But remember we was told, I think his lawyer was the one that was sick. Somebody's lawyer was sick. All right, so I'm just going over my old notes so y'all can know what happened. Just kind of like and Davis was another one. That's the trustees. The part 2 was about the trustees. I guess we'll have to do a part 2 because I'm not about to be here for another 2 hours because I actually have an event to go to at 7 o'clock, y'all. I gotta go marketing. So there is gonna be a part 2. Okay. Hopefully let's do part 2 tomorrow morning. Okay, because we already got the reading of Miss Stephanie Wiedemann for Tuesday. I rescheduled that. So tomorrow, before I go disappear for the weekend, we're going to finish, watch what we missed as far as the trustees to see who's running for the trustees in Thornton, because we still have an issue. We need to make sure that these people are not party driven, that they're for the people. And we also know that Thornton residents has to come up with a date, petition for a date so they can choose a trustee. Y'all remember that. So we still got to keep our eye on that. So let's finish listening to see what Nate Fells have to say. You got the eye of the tiger. And then we're going to put the best comments up there. I see we got a lot of Nate supporters, guys. I appreciate you, y'all. I don't even know that man. I just got love for him. Like, I see a good soul and they young. We need the young people to be out there. These old people be compromised and stuck in their damn ways. I'm just saying. Let's move forward. Let's get him up to Burgundy.
Oh my goodness.
It's 4 of those objections and get them knocked off.
This is how you come through. This is how you come through. You have to nail that.
Hit the like button. Thank you. Look at Nate looking like a young lawyer.
Hey Nate, good to see you. Good to see you. We
like a young lawyer. Shout out to Burgundy Blue. You did an amazing job, girl.
For you.
I had to take a nap. My ass was like, they were like, is Grace asleep? I'm sorry.
You don't have it. No, thank you. You don't have anyone else contesting you yet today, right? That's it?
That's it.
Okay, good. Okay, so you got 2 out of. Oh, let me put you on camera if that's okay.
Sure.
Go ahead, Nate. So anyone else contesting you today?
So actually it was 3 different objectors today. 2 of them had attorneys, and then the other one was Keith Price and Michael Smith. Now, Keith Price and Michael Smith had about 5.
Okay, I'll bring you on out here with us because she's starting back up. Come on.
Mm-hmm. Yeah.
I'm sorry.
No.
So Keith Price and Michael Smith did end up, they had like 5 objections. So I was able to go up against 4 of those objections and get them knocked off. 1 objection remained sustained, and so that's going to have to be appealed.
Mm-hmm.
And so I'll be going to the Cook County Electoral Board to appeal that and try to get that passed through the Cook County Electoral Board.
You did pretty good, you know.
Thank you. The other 2 objections were attorneys, and so I went up against attorneys by myself with no attorney, and I beat them. So I beat 4 of Keith Price and then 2 attorneys. So I think I did pretty good, but I didn't do good enough. I like to have got everything passed. So still working on getting on the ballot. So just gonna do what needs to be done, you know.
We'll see you December 30th at 10 a.m. and we just appreciate you. A lot of people in the comments say, "Fan, good job. You're fighting." We see how you was out there getting the signatures door to door.
Absolutely.
So keep on going. Don't give up.
Thank you. And if you guys can donate, please do. You know, any dollar helps real. I think I will end up going to get an attorney this time because I don't know who's going to be on this board. So I hate that a lot of the attorneys are booked up and used up by these elected officials. It's hard to find one locally, but I have to at least consult with someone and then go up there and do what I got to do, you know?
Yeah.
So it's for the people, you know. I'm not doing this for me. I don't have a team right now. I'm literally doing it by myself. Once I'm
What happened, babes? Hold up, y'all. Something froze. Let me just refresh it because I was looking at something else.
The most affordable 12-month GL.
They wanted to give us a commercial. Let's just finish listening to what he got to say, and then we're gonna go to Nate Fell page.
You guys can donate, please do. You know, any dollar helps for real. I think I will end up going to get an attorney this time because I don't know who's going to be on this board. So I hate that a lot of the attorneys are booked up and used up by these elected officials. It's hard to find one locally, but I have to at least consult with someone and then go up there and do what I got to do, you know?
Yeah.
So it's for the people, you know, I'm not doing this for me. I don't have a team right now. I'm literally doing this by myself.
Every time it pause. I'm trying to fast forward. I don't know if that's the last part of it. All right. So shout out to Burgundy Blue. She did an amazing job. Camera was on fleek. Sound was like on whoa. Shout out to you, girl. All right. So let's get to Nate Phil page, and we're going to get to some of your comments as we read this. So this was some of the comments that was highlighted. Again, I want to say shout out to Mr. Roberts who stopped by today, gave us a little bit of insight. Said Keith Price and Michael Smith may be looking for Chris Clark for future jobs. That's probably why they laid off of him. Allegedly, they were his challenges. Not allegedly, they were. Okay, they were. Next, the judge explains different cases in the binding process. They went with the latest, and that's what tripped up Nate. So we're gonna verify that one. What was the latest one? And was that? But it seemed like it was a lot that was going for allowing his paperwork to submit. That's why we're gonna pull up 10 and see how many is that would support him just being able to submit, because this was an administrative technical error. It really wasn't. He did it on the same day, same time. He didn't even mess up. It's all based on interpretation. So we're going to look at that. So great. Thank you, Ms. Shear. You've been amazing, and you're very intelligent. I can tell. All right, Coffee. And for connecting the ugly dots, he will not be Riverdale trustee. I know so many people in Riverdale who are against him. So pay attention, y'all. Pay attention to what's going on with him. I'm sorry, I thought I had to comment on the page. Yeah, because y'all got to vote these people out. I don't know who they think they are having all these jobs, 30 jobs like a Jamaican, right? Next, I'm rallying up my family and neighborhood in the South Highland and Riverdale to back Nate. So while you say that, you are amazing. Thank you. You make my heart melt, because I'm like, come on, y'all. Come on. Get behind this young man. Y'all keep having these old whippersnappers over here playing y'all like chess. Old gangsters like Miss Loretta Wells, 50 years, and her husband. Okay. Now, this is his campaign website. Also, it says don't forget to donate. All in, y'all go get right here. This is his number. Let me put this on here for y'all so y'all can get in on any updates that has to do with his campaign. Okay, I'm gonna put this number on the screen so you guys can see it. We're going to get Nate Phil some support here. We got people in the family like, man, we rallying up the squad. Because I want to say this. I know people want people with tenure, with background. We also want someone who's flexible, someone willing to learn. And also, I'm not saying that Zuccarelli taught him everything he know, but at least he watched Zuccarelli in some of his practices, have an idea. I don't know what Zuccarelli showed him, but to be under him and get some type of mentorship says a lot. And to be open, and some of his things that his agenda is great. It is focused on the veterans, it's focused on job creation, it's focusing on self-cultivation. He even talking about having some like gardens out there. Like, man, he got some ideas, y'all. Y'all need a young whippersnapper. But I'm just throwing that out there. You know, I like to give people a chance. So this is was posted on the 18th. He like, listen, all on the campaign trail this week. And I pray that he continue to move forward as though he's not knocked off the ballot. How you be like, mind over matter. Okay? Don't tell Grace no. I told you, did y'all know I got kicked out the nursing program because I missed the date? Oh, yep. I came in swinging. They was talking about me and everything before I came in. Talking about she hood, she don't appreciate this, and I stood up for my shit by myself. So fight, Nate, fight. Okay. I know he has some other stuff. When we do the part two of the case law and everything, we'll put up more of his information with whatever he has to, share with you guys to support him. But people are rallying behind you, Nate. You see what they're saying? He got my vote and some more votes. I got behind him in Riverdale and South Holland. Who are you talking about? Who are you talking about? Smith? Hold up. You said South Holland. Tell me, I got a little confused. I know I'm 2 hours in getting all sleepy. All right, he's going to do a great job somewhere in the office. I think he is. Whatever it is, that man, yeah, he came out like a little lawyer. Not no emotions. Even when the judge called him like, no, you got to direct it towards me. He fixed it and just got focused. That's what I'm talking about. Okay. So, Kathy, the biggest thing someone can do for Nate right now is to get him a lawyer that knows electoral law, election law. Exactly. Next, she gave their last mayor a heart attack. That's why he lost against her. You know what? I told y'all, I said the same thing, but I said it different. I said she did voodoo. I'm telling y'all, it's black magic. How she got two positions and one had a heart attack, one had a stroke. Weird. I'm with you, Cafe. We know what's going on in the spiritual realm. It's over there causing, excuse my language, thunderstorms and shit. Sound like they were just fouling to see what would stick. Exactly what lawyers do. They try to pull that like this, and ain't nothing really stick. Got knocked down. He even knocked down the lawyers. I donated to his campaign and to get him a lawyer he deserved. Let me see if he got a GoFundMe or something up. Where is this thing at? Okay, hold on, y'all. There we go. Hey, let me go to his page real quick. Y'all can go straight to his website, so it ain't even no go. See, he ain't even hood. He like, I don't need to go for me. Y'all go right through my website, and y'all can donate right on my website the right way. So y'all can donate here. Let's see what they got going on. One time. Y'all know, if y'all not rich, y'all can put $10, $5. You know what I'm saying? Help this man out. So this is it. He got his already set up, nice website and everything. All right, Nate is ready. No GoFundMe. He ain't no GoFundMe, baby. All right. Grace, they voted semi-correctly by how judge explained the latest case law. Appeal will remedy that, hopefully. I think so. I like the way you're thinking. I appreciate you for being part of the family. And let me know, would you like to be a mod? And Isaac, he disappeared. I appreciate you guys adding substance to the conversation, and all you guys are. It's just a few people just start standing out to me. And, I want to create a tone here where we like to do legal research, and I need help too. I need people who are like, oh no, that's not what they said. People who got the eye of the tiger. So let me know, share if you want to be a mod, because I appreciate what you add to the conversation. The only thing Nate got hung up on is that one piece of paper not stapled to the rest. Case law leaves that up to the appeal. Was Keith allowed to go through Nate paperwork? And that's what we need to figure out. Okay, Nate need to go and do a Freedom of Information Act on a Freedom of Information Act of the people who wanted to see his paperwork. If that man reviewed that paperwork in the clerk office as he stated without having his information put in as a Freedom of Information Act, did not know you could go in physically to do that, it has nothing to do with his position. Like, you remember when he said that Carmen could have went in and examined Freedom of Information papers about the finance, or got copies, and it was like 100 of them, and they was just like, let her look at it. But that's in a different capacity. So yes, Nate need to look into that, because that sound a little suspect. Fuck you, indeed. You was back there looking at people's paperwork. Yup. Close up, Keith face reminds me of the Muffet. The Muffet, baby. A Muffet. A Muffet, baby? Don't think so. I don't trust that lawyer from Delgado Group either. Is she from Delgado Group? That lady? If it is, she actually did a great job. I'm gonna be honest. She seemed very fair, and she tried to warn them. She's like, y'all gonna be spending more money. Hello, I recommend. That was the only thing one of the ones she did not recommend, and left it up to Everett, Wells, and Gonzalez. You see what I'm saying? She's like, I'm gonna let y'all make a decision, but she kept explaining it. And shout out to Jane Lopez Thomas. I appreciate you. Like I said, I used to put down my way of thinking, dummy myself down, because I know I'm from the hood. I'm from Newark. And at some point I just said, fuck it. I'm about to be who I am. I'm like, do you know that the stars is they be like, girl. I'll be like, what? I would just be me. Yeah, but I had to crack that joke. I was just cracking jokes when I was like, they black. They are black. But this is what we do. We're gonna log off. I appreciate you guys being with us today. We're gonna get a word from our sponsors and a word from our favorite super mayor.
Leader. They want to hear from the mayor. If y'all ain't learned that yet. The mayor, not the trustees that don't do nothing, that only run their mouth. Y'all don't do no work, no work. Y'all forget I am the leader.
Every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections. You were first elected in 2021?
No, 2013 was my first election for trustee. I was a trustee. I sat where they are.
Right.
That's why I know the law.
Council.
Yes.
Elected mayor 2021.
Yes.
Term is 4 years?
Yes.
Okay. Plans of running for re-election?
I'm running for both my seats. And I'm going to win them.
So, and when is the election for Thornton Township?
2025.
So those elections at the same time?
They are.
Would you like to learn a brand new and innovative way to invest your extra money that has a low barrier to entry and low competition? What if I told you that it is a guaranteed method to get up to 18 to 20% return on your investment? Tax lien and deed purchasing is the only way to get into the real estate market through the back door. No credit and no loans needed. This method isn't commonly taught, and therefore the competition is very low, for now. Put together a 14-hour info-packed course which will teach you everything you'll need to know to get started. Learn at your own pace, step-by-step guided video and aids to start you on the TLC deed investment process. The course offers many learning tools for new investors, helping ensure you safely invest in tax liens and deeds. Contact us today and join